Hello, my name's Andrew Robichaud with the Valley Vanguard. This week, the Valley Vanguard decided to attend the Moot Court demonstration that was hosted by the Law Club in Wicks Hall. Here are some highlights from that event.
The officers performed their investigation after the court had decided in United States v. Warshak that this was an unconstitutional statute. Beyond the fact that this statute had already been proven to be unconstitutional, the officers in this case did not abide by the statute. The government violated 18 U.S.C. 2703, sections A and F, because they viewed Mr. Comerford's conversations as they were happening. And according to those provisions of the statute, the government should have only been able to use the information that was stored for more than 180 days.
So this was a moot court demonstration. We were essentially doing a model Supreme Court argument. So we had the petitioner and respondent arguing a case in front of a mock Supreme Court.
We get up and be counsel pretending to speak before the justices of the Supreme Court. And then the judging panel pretends to be, obviously, the justices of the Supreme Court. And we give our arguments, and they decide the merit of those arguments and how well we presented, and they judge accordingly. However, if we look at the test for true threat established in Watts v. United States and established in Brandenburg v. State of Ohio, and further established in Lockhart v. United States, we see that the true threat, as defined by the government, is one which an objective person would consider is action or words which an objective person would consider threatening, and action or words which the speaker intends as a threat to the receiver or intends to communicate to the receiver.
We participated in a regional competition. Some of our groups went to Worcester, Ohio. The other groups went to Orlando, Florida. And then the groups that made it into the top out of those two regionals went on to California to compete in the national.
In the case of Donovan versus Dewey, which is referenced within Illinois versus Kroll, has stated that when the government, when Congress or legislator or other lawmakers deems that a situation doesn't need a search warrant, an administrative subpoena can be used instead. So as opposing counsel tries to argue that an administrative subpoena is completely against the Fourth Amendment, we find in the case of Donovan versus Dewey that the court finds in certain circumstances that it is permitted to use only an administrative subpoena.
Good afternoon, Honorable Chief Justice and Associate Justices, and may it please the Court. My name is Ashley Hansen, and I rise today on behalf of the respondent of the United States of America regarding the First Amendment issues in the case at bar. Your Honors, as you well know, the First Amendment protects the right to freedom of speech for all individuals unless the government can provide a compelling interest to limit that speech, such as when someone threatens the life of our president. In this case, the lower court held that Mr. Comerford's actions in aiding and abetting threats against the president fell outside of the realm of constitutionally protected free speech.
Most of the members of the Law Club participate in the Moot Court, and that's primarily our big event over the fall semester. We also are working on, right now, touring some law schools, as well as doing some LSAT prep that Ashley's going to be doing in just the next week. And we also do dinners or events with attorneys so that students can have that one-on-one interaction and build connections and find out more about the profession of law.
This is my first year getting involved. I started joining the moot court team, and once I started seeing how much I enjoyed, doing the law club activities and making the friends, I decided to join law club.
Okay, I've been in Law Club for 4 years now. I was actually one of the co-founders of the Law Club, so I have been involved in that for a long time, and then Moot Court, this is my first year.
Well, my favorite part is definitely just the adrenaline rush you get when you have to stand and speak in front of a big group of people with almost nothing to say.
My favorite part were the questions. They're unexpected, you're unprepared, you just have to wing it and hope that you know what you're going to be talking about.
I would have to say my favorite part of it is probably answering the questions of the judges. It's fun. Sometimes you get into a little verbal sparring with the judges, and it's always fun to be able to argue your point and stick to what you're talking about.
I think my favorite part was being like the respondent or doing like the rebuttal, because I liked taking the other person's argument and just like ripping it to shreds and telling them why it was all wrong, and that was probably my favorite part. And then of course traveling. I got to go to California, so that was really cool.
If you are considering going into law or would like to join the Law Club is hosting an informational night on March 21st.